Well, in 1935, the Supreme Court starts to essentially declare the New Deal to be against the law or against the Constitution. It begins in earnest to strike down not just New Deal programs, there were a lot of New Deal programs, but the centerpieces of the New Deal. It begins with the National Recovery Administration, the Recovery Act, the NRA, and then it moves on to the AAA, the Agricultural Adjustment Act, the Farm Program, and other central pillars of the New Deal are knocked down in short succession, usually, but not always, by a very narrow margin, 5-4. And so there's a very real question by 1936 whether Roosevelt can actually get anything fundamental done in the country, because the Supreme Court is standing in the way of everything, not just in the way of the federal government, but in the way of the states, because states, meanwhile, are passing laws trying to implement minimum wages and all sorts of things, set maximum hours for certain kinds of jobs, and the court begins to strike in earnest these sorts of pieces of legislation down too. So, as Justice Stone put it at the time, the court seemed to have tied Uncle Sam up in a hard knot, and it wasn't clear how he or we were going to get out.
Now, even though no one in this audience is nearly old enough to remember anything about Franklin Roosevelt, I think he's a familiar figure to many of us here. Talk about who was on the Supreme Court at this time. Who were they? And just characterize the court at this moment.
Well, this was the oldest court in American history, and this is something that people were aware of. They were known popularly as the Nine Old Men. And the oldest was Brandeis, but there were many others who were nearly as old as Brandeis. And the court had been pretty reliably, but not consistently conservative for a number of decades by this point, really for many decades. And there was a clear sense from the time that Roosevelt was elected in November 1932 that there was going to be a confrontation between FDR and this court. It's not simply that they were old, but that many of them, not including Brandeis, but many of the older justices were really 19th century men in spirit. You had Willis Van Devanter, who was old enough to actually remember as a boy watching Lincoln's funeral procession. Wow. Charles Evans Hughes, who was the Chief Justice at this time and had been on the court previously in 1910, Charles Evans Hughes, when he was a student at Brown University, not only had no running water or central electricity in his dorm, but he had two closets, one for his stuff and the other for the coal that he would use to shovel into his heater. So,
and my favorite, perhaps the worst human being ever to serve on the Supreme Court, James McReynolds, who the story goes, was such an appalling anti-Semite that used to get up and leave the conference room when Brandeis or Cardozo would speak.
And not only that, but when Cardozo was inducted as a justice, McReynolds was forced to sit through that ceremony, so he pulled out a newspaper and rustled it very loudly throughout the induction ceremony.
And he got confirmed. So that's the court. And who was the Chief Justice?
The Chief Justice was Charles Evans Hughes, and I'll say something about him in a second, but I think just to go back to your last question, the other thing to know about this court was that they didn't use the term at the time, but to use a term of ours, it was a very activist court. And between 1933 and 1936, it was overturning federal laws at 10 times its previous rate. And so this was a court on a mission, and it really did, the conservative justices really did see it as a mission, a holy war, some of their supporters said, against communism and anarchy, which they saw, communism at least, in the New Deal.
And, without descending too far into legal geekdom, what was the rationale what was the legal reason that all these New Deal laws were unconstitutional?
Well, there were a lot of different doctrines and clauses invoked, from the Commerce Clause to the Contracts Clause and the doctrine of substantive due process and a whole range of other things that were used to strike down these programs. Many old doctrines were revived for the task and so forth. But really, fundamentally, this notion, the conservatives' notion of constitutionality, was rooted in the 19th century, in the laissez-faire doctrines of the late 19th century, and of the sense of constitutionality as implying a few things: a limited government, states' rights, and a constitution of limitations. It was not, as Roosevelt felt, a broad avenue through which a lot of things could pass and get done. It was a constitution of limitations, and sometimes, as one of the justices said, those limitations pinch.
Now, one of the questions that often comes up with Supreme Court justices, it's certainly a question that I have thought about a lot in terms of the period I wrote about, is how much are the justices applying principles and letting the chips fall where they may, and how much are the justices finding legal principles to accommodate a political result that they want to reach?
Well,
and so as you get to this critical New Deal period and period of conflict, how does that trade-off look to you?
Well, certainly there were a lot of precedents that could be and were applied to strike down social legislation, whether it was before Roosevelt or particularly during Roosevelt's presidency. There was no shortage of opportunities for the conservatives to do that, but there were also very many opportunities for them to sustain a lot of this legislation. There were other precedents that they could have called upon as well. So both options were really there in front of the court. And what you see during this period, and I alluded to this a moment ago, is you see the justices scrambling in some cases for doctrines that have been out of favor for decades, that everybody thought had sort of declared dead decades before, and suddenly they're applying them with vigor to these New Deal cases, or applying two of them to the same New Deal case when they could have decided it on narrow grounds. They're deciding on the most sweeping grounds possible so that they are essentially preemptively declaring any legislation of this kind unconstitutional.
FDR, obviously the protagonist of your book in many respects, the protagonist of the period. Talk about his attitude towards the court. I mean, he is one of the obviously great figures in American history, but talk about how he looked at the court as a political institution, as a legal institution, and as the conflict between him and the court grew.
Well, he saw the court as a political institution, and that probably won't surprise anybody here, but when Roosevelt in the 1932 campaign gave a campaign speech, I opened the book with this. It's chapter 1. He goes to Baltimore in October of 1932, and he's campaigning against not only Hoover, but against the Republican rule generally, and he says, the Republicans have control of the White House, they have control of the Congress, and for good measure, they also have control of the Supreme Court. That would seem a fairly uncontroversial statement today, but it was explosive at the time, or at least the Republicans tried to make it explosive, shocked that he would imply that the Supreme Court was in politics. There still was this, shocking, there still was this notion, very strong then, it still exists today, but not quite at this level, that when someone put on the judicial robes, that he parted with his politics. He might take an idle interest in politics, like following the pennant race in baseball, but they were above this sort of thing. They weren't interested or engaged. Roosevelt never bought that. And one of the first things that he asked his new Attorney General, Homer Cummings, to do when he got into office was to figure out how many of the appointees, how many of the judges on the federal bench at all levels had been appointed by Republicans and how many by Democrats. And there were only 28% of federal judges were Democrats by affiliation. And so they felt that they had a big partisan problem on the federal bench. And Roosevelt didn't think fundamentally this was about the Constitution. He thought it was about special interests and politics.
So all through his first term, he has these problems with the laws getting overturned. When does the idea start to percolate to do something about the court itself?
Well, interestingly, for the first time before he's inaugurated, he's aware that there's going to be a confrontation with this court. There's talk in the press about an inevitable. If Roosevelt keeps half of his campaign promises, there's going to be a confrontation. And so one of his key supporters, an incoming senator from California, actually sits down with the incoming Attorney General and says, what are we going to do about the court? What are we going to do about the old fossils on the court, as he put it? And he floated an idea that they would pass a constitutional amendment to relegate any justice past the age of 72 to emeritus status, just sort of push them aside. And so this is beginning to circulate and starts to circulate in the press even before very many New Deal programs have passed.
So the notion of doing something to the older justices is in the air even early in the first term. Now, one of the curiosities about the Supreme Court that a lot of people don't realize is that the number of justices is not established in the Constitution.